Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about motives to fabricate sexual assault complaints. Cases that should have gone to the Supreme Court of Canada, but didn't. An individual who was charged in a sexual assault case wanted to introduce aspects of the complainant's diary for the purposes of cross-examining her on the basis of her motive, potentially, to make up the allegations. Their position was that the excerpts from the diary essentially demonstrated that there was a motive to get the accused individual by fabricating these stories. Under the current law in Canada, in order to introduce a record that belongs to a complainant in a sexual assault trial, a person is required to make a separate application to the court, which was denied. And this was one of the first opportunities that the Supreme Court of Canada really has had to address this regime and this mechanism to challenge evidence, particularly when it comes to the unique issue of a motive to fabricate. And unfortunately, the Supreme Court of Canada denied leave to appeal, which leaves open the question, how do we really analyze the significance that a motive to fabricate plays in assessing the regime? While it may be that certain aspects of records have to be challenged, doesn't there have to be a line drawn, and shouldn't there be clear lines drawn for judges when they're hearing cases like this all the time, where it's alleged that records may contain information that suggests a motive to fabricate, a clear line for judges to determine how those applications progress? And as we see these applications happening in trial level courts all across the province every year, every day of every year, then we also know that we run the risk of inconsistent judgments in relation to how these issues are to be assessed. And that's exactly why the Supreme Court of Canada is there, to make it consistent across the country and to resolve inconsistencies. This was an opportunity for the Supreme Court of Canada to be at the forefront of the interpretation and application of relatively new legislation in Canada when it comes to some of the most serious cases that come before it, particularly where this added element of a motive to fabricate is added, which suggests that there's a potential, if the motive is legitimate, that somebody innocent is being set up for a crime that they didn't commit. These are issues of national importance that the Supreme Court of Canada should be listening to. And unfortunately, the Supreme Court didn't accept this case, and we'll have to wait for another day to hopefully have some guidance from the Supreme Court of Canada on a consistent standard for motive to fabricate in these records application regimes. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.